Mike Rappaport said a few moments ago that Justice Scalia didn't like the modern common law. And I think that's right, and I think that's because Justice Scalia thought of it in terms of what he learned at the Harvard Law School, I guess in the late 1950s and early 1960s, where common law was seen, and this is eerie taken to extremes, common law was seen simply as something the judges came up with. They did not take seriously the notion that there is unwritten law and that it's genuinely law. And one thing that's happened in parts of American legal scholarship in the last few years, and especially including in constitutional law, is an attempt to take more seriously the idea of unwritten law, in part to understand better what was going on in times when people took more seriously that idea. Something else Mike mentioned was the corpus juris. One of the questions that I'm wrestling with in this draft is whether the American corpus juris includes what in the 21st century would seem like a strange thing, which is an unwritten law or a body of unwritten law that is immune to the lawmaking power of the states, but not for reasons of federal law. And I'm going to suggest that a lot of people thought in the first half of, or I have suggested in the first half of the 19th century, that indeed the corpus juris included legal rules like that, and that the Privileges or Immunities Clause of the 14th Amendment connected to legal rules like that. A very short version of the paper, since one of the things I'm supposed to do here is summarize it, a very short version of the paper is that the idea of citizens' rights is because citizenship is connected to political organizations, to legal systems, that the idea of citizens' rights is about what goes on in some legal system. And so in order to know what are the rights of citizens in any legal system, including certainly the American legal system, it's necessary to know not only what does the concept of citizens' rights mean, but to know some things about the law, about the corpus juris, including, for example, does the corpus juris include these seemingly strange things, legal norms that are not written down and, putting all this in American terms again, immune to the power of state lawmakers, even though that immunity does not come from federal law in the American federal legal hierarchy set out in Article 6 that we're so familiar with. That's the short version. The longer version begins with Slaughterhouse and the question whether the Privileges or Immunities Clause of the 14th Amendment might give what we would today call substantive type protection to the kind of legal interest that was at stake in Slaughterhouse itself, which was pursuing a calling, being a butcher, or also some of the legal interests that are referred to, and here I say referred to advisedly, by the first 8 amendments of the Constitution, unenumerated rights and rights enumerated elsewhere. Can the Privileges or Immunities Clause give that kind of protection to them? An immediate response is Justice Miller's response. Look, it says, of the United States. This is a complex legal system that has both state and federal law, and that of the United States part is telling us something we already knew, which was that, yes, there are citizenship rights that attach to citizenship of the United States that primarily come from federal law that, of course, are immune to state lawmaking power, Article 6, but don't include following or calling, don't include being a butcher. That is, whether you think Miller was right or not, and whether you think it was fair of him to add some emphasis to of the United States, those words are in the 14th Amendment. His argument requires a response. Well, recently, Judd Campbell has told us something about the response that was available in the early 1870s, which is the idea that the rights of citizens of the United States were not limited to their rights coming out of their political connection, other connections to the United States as a sovereign, that they had both those special federal citizenship rights and general citizenship rights, and that although pursuing a calling, being a butcher, wasn't a right of specifically federal citizenship, the important stuff like going to your sub-treasury is that kind of right, that those were rights of general citizenship and therefore are at least referred to by the phrase privileges or immunities of citizens of the United States. Okay, but a comeback to that is, and part of this paper is about this, a comeback to that is, yes, but that concept of general citizenship rights as attached as being rights of citizens of the United States was devised as a theory of Article 4 of the Constitution. And one thing that was clear at the time of Slaughterhouse and through most of the antebellum period was that there was some substantial power in the states to define the rights in that category. And I give some examples of that in the draft. Therefore, I think two things follow. The first is a rights status, as assuming that the 14th Amendment uses there's both national citizenship and general citizenship rights in there, that a rights status as a privilege or immunity of citizens of the United States does not mean that the right is therefore immune to the lawmaking power of the states, because those rights are themselves partly defined by the lawmaking power of the states. The second conclusion I urge is that the word abridge in the 14th Amendment does not take away whatever power the states had and exercised throughout the antebellum period to define those rights to some extent. And I keep stressing to some extent, because some power in the states to define the rights, the privileges or immunities of citizens of the United States does not entail complete power, does not mean that all of those rights are intrinsically immune from the legislative power of the states for reasons unconnected to federal law. And so that suggests an understanding of abridgment, where abridgment by a state is for the state to do something other than exercise whatever power it has. And I keep saying things like whatever power it has to hold open the possibility that its power is limited. Whatever power it has to define the rights, which are, on this hypothesis, privileges or immunities of citizens of the United States. Abridgment, for example, is taking away the rights that are given to some people from other people, as, for example, in a black code, or trying to operate on citizens' rights that are immune from state legislative power because of federal law. Article 6, that would be an amendment. That would be an abridgment. Abridgment would also include an attempt by a state to alter a citizen's right that is not subject to the power of the state legislature for reasons other than federal law, if there are any such rights of citizens. That's the big question. That's the question I began with, are such odd things in the corpus juris? And my claim is that enough people believed there were in the middle of the 19th century that you could see how people like that, including, I believe, the dissenters in Slaughterhouse, would have thought, first, this is a legal rule, the content of which is the idea of citizens' rights and refers us to whatever are the rights of citizens of the United States under the American legal system in the American corpus juris, and who also believed, well, they believed in natural rights is one way to put it. They also believed that some of the rights of citizens were immune to the legislative power of the states, not because of federal law, not because of Article 6, but because they just were, because people had rights, and they had some connection to nature. Was that a live possibility in the middle of the 19th century? Yes, it was. Some people believed that. I think the most important manifestation of some belief along those lines was the principle of vested rights. Legislatures cannot take the property of A and give it to B. And you see in the draft some discussion of, and I got to thinking about this more when I read Chapman and McConnell a few years ago. Exactly what's going on. Is this a structural principle in the due process clauses? And as I say, I think yes, but it's not exactly the structural principle that Nathan and Mike talked about. And rather, I think that the fundamental principle of protection of vested rights is that vested rights are protected. That is to say, legislatures don't have power to take the property of A and give it to B, and that is an example of the kind of thing that some people believed in the 19th century. So yes, the law might have been like that. And so it is possible that this claim about the meaning of privileges or immunities of citizens of the United States could connect to some legal facts. And it's easy to neglect that sometimes legal results are the combination not of, say, meaning and some non-legal fact, but are the combination of meaning and a legal fact. Like when a meaning refers to somebody's rights, well, what are somebody's rights? People thought there were rights like that. And so that would explain how it would be possible for people like the Slaughterhouse dissenters to believe that the privileges or immunities of citizens of the United States referred to by the Privileges or Immunities Clause, but found somewhere else, included some rights that were just not subject to the lawmaking power of the states because they weren't. And if there were such rights, and this connects to what Judd and Steve and Will were saying yesterday, if there were such rights, then one consequence of having the Privileges or Immunities Clause is that in addition to whatever is the non-federal protection from the legislative power of the states they had before, those rights get a new federal law of protection that, among other things, generates jurisdiction under Article 3 and under Section 25 of the Judiciary Act. So yes, that was a possibility in the mid-19th century. I think some people really believed it. And so for them, the two components, one of meaning, one of other parts of the corpus juris, came together. And so yes, they could believe now there is a new protection of rights further secured, of rights that were already in an important way secured. That raises the question, well, some people believed it in the mid-19th century. Was it true? And what I think is the crucial question today, which is it true today? Are there any such rights in the American corpus juris? I have doubts about that, and I even have doubts about the mid-19th century. But my primary claim is that the right questions are, first, is the original meaning or the meaning, however you want to think about it, does the meaning of privileges or immunities of citizens of the United States include those rights of general citizenship, not associated with national citizenship, and hence not protected by Article 6? That's the question about meaning. And then the question about the content of the corpus juris is, were there then or are there today any of those sort of strange legal creatures that were not subject to the lawmaking power of the states, even though their immunity from that power, lawmaking power, didn't come or doesn't come from Article 6 and the supremacy of federal law. And I want to hear what Mike has to say. The last thing I'm going to say is that I'm really glad that we get to hear from Mike, who had the good fortune, I guess some time ago, to be a colleague of the founder of modern privileges or immunities scholarship, David Curry.